matter of Malik and others.
May it please your ladyship, my lord. There are two appeals in two different actions before
Yes.
the court.
Yes,
As the court has seen from our skeleton arguments. Both are from parts of an order made by Mrs. Justice Bacon in February 2023. And in both cases, permission to appeal was given by Lord Justice Snowden, who directed that the appeals be heard together. I appear for Zacaroli Malik in both appeals.
yes.
He's the appellant in the first and is the first respondent in the second. And my learned friends Thomas Munby, King's Counsel, and James Kinman appear for Iftikhar Malik, who is the respondent in the first appeal and the appellant in the second appeal. And we have agreed, subject to the court's views, that of course that it would be convenient to hear the appeal in the 1987 possession action, my appeal first.
Right. I was about to ask you, had you divided up the time and the approach?
We've agreed that that's the appropriate approach, and certainly from my point of view, we should have an equal amount of time overall. I may spend a little more on my appeal and less time in responding to my learned friend's appeal. But so the court has, I hope, got the core bundle and the supplemental bundle, 2 volumes of authorities, and then there were 3 pages that we provided to be added to the back of the supplemental bundle. So I propose to begin with a few points about the history of the claim, and then I'll follow the order in my skeleton arguments and address.
We have had an opportunity of quite extensive reading.
That's very helpful. Lady, I will take it quickly.
No, take it in your own way, just so that you know that we've got.
That is very useful, lady. Can we begin with the core bundle? Go back to the 3rd of July 1987, tab 20.
Sorry, this is the 3rd of July 1987.
Yes, 3rd of July 1987. That's when this action began,
Yep.
with this writ that was issued in the Queen's Bench on that date. And on page 260, paragraph 1, it was pleaded that the plaintiff, Iftikhar, had been the leasehold owner and entitled to possession at all material times of the flat. Paragraph 2 said on the 6th of January 1987, the first and or second defendant, the second defendant being Sarah Malik, who at the time was Zacaroli's wife, wrongfully entered on and took possession of the said premises and have thereafter wrongfully remained in possession thereof. And a prayer on page 262, which is relevant parts of 1, possession of the premises, and 5, mean profits from the 6th of January 1987. It's also relevant to look at the claim that was started later that month by Zacaroli, which is in the supplemental bundle. Tab 2. This one was commenced in the Chancery Division on the 28th of July 1987, and it was commenced against Bilal Malik, who was the father of Iftikhar and Zacaroli, Taj Begum Malik, who was their mother, Iftikhar, and then Safraz and Ilyas, who were the 2 other brothers in the family, and then a family company, Still Goes Investments. And the relevant allegation in paragraph 1, it was alleged that there was a partnership, that the parties were 1/6 partners in a family partnership, trading in carpets. And then at paragraph 3, it was alleged that the flat was purchased in December 1978 for and on behalf of the partnership, and was at all material times intended to be, and was in fact, save for a period when he was in Pakistan managing partnership interest there between 1982 and 1986, occupied by the plaintiff Zacaroli as a permanent family home for himself, and was to be appropriated to him out of the partnership assets. And the relief that was claimed on page 40, I could invite the court to just look briefly at paragraphs 1, 2 and 3. there were two actions. In one, Iftikhar was saying, it's my flat, give me possession of it. And in the other, Vakar was saying it's a partnership asset held on trust and had been purchased and appropriated to him as part of his share in the partnership assets, and he was entitled to reside there, or reside there at least until the assets were dealt with by an order of the court. The subsequent procedural history is summarised in Mr. Jarvis's judgment, and I know the court has had a chance to look at that. That is in tab 11 in the supplemental bundle. I certainly don't propose to go through all of the history, but I do want to pick up 1 or 2 points. The procedural history, I would suggest, can be divided into 4 phases. The first phase was from July 1987, when the actions were commenced, to July 1988, when there were a number of applications and orders. And the relevant ones are page 102, paragraph 30. That was the order for the payment of £25,000 by way of security of costs in the possession action, to be paid by the 1st of January 1988, and if not paid, then there was a stay.
I'm sorry, I haven't got the right page for that. You were taking us to SB 11 of decision and judgment of Mr. Justice Jarvis, and then you took us on to page
102, my lady.
102. Thank you.
And paragraph 30.
Thank you. Sorry about that.
No, my apologies. And then one sees in the next line of the paragraph 31 that on the 18th of December, Iftikhar appealed that decision. And then at paragraph 33, on the 19th of February, the matter came before Judge Blackett-Ord by way of an appeal, and that appeal was dismissed. So he was ordered to pay £25,000 security costs. He appealed it. The appeal was dismissed, and the action was stayed for breach of that order. There was nothing similar in relation to the 1987 partnership action. There was no order that Vakar was in breach of, and the judge records that there were difficulties in serving it on members of the family. He refers to the 2 actions as first action and second action, but I'm afraid sometimes he mixes them up and says second when he means first, which is why I prefer to call them possession and partnership. That way I don't have to remember which came first.
I will inevitably get them mixed up if we go 1 and 2.
There were also proceedings in Pakistan, of course, and an important event in those came in May 1988, when Justice Hussain dismissed Vakar's partnership claim. Vakar said in error, and he appealed that by something called a revision petition. And that takes us to the second phase, which happened in started in July 1988. And one sees that in paragraph 50 on page 105. The various applications came for hearing before Mr. Justice Knox, and he took the view that it was better to adjourn them until the revision petition, the appeal in Pakistan, could be dealt with, because if Vakar's Pakistan partnership action was dismissed, that might resolve the partnership action in England. So then there was the second phase, which was from July 1988, when that happened, to December 1991. The revision petition progressed slowly in Pakistan, and there were also other proceedings started in Pakistan in 1989. And in 1989 and 1990 in England, nothing much happened. The court was told that matters were progressing in Pakistan. And the last communication with the court, one sees in paragraph 59 on page 107, that on the 6th of December 1990, Stevenson Harwood, who were acting then and now for Iftikhar, wrote to Chancery Listing saying they didn't want to have matters relisted because of difficulties in Pakistan. In September, they asked the listing office not to enter the action in the warned list for trial. And in October 1991, the clerk of list confirmed that it had been removed from the warned list. And that date, the 1st of October 1991, brings to an end the second phase. Then As far as the court was concerned, nothing at all happened for another 19 years, or more than 19 years, 19 and a half years, until February and March 2011. So nothing much happened between 1988 and 1991, and then from 1991 on, nothing happened until 2011. In the meantime, there is, in Mr. Jarvis's judgment, from paragraphs 60 to 70, a summary of the evidence that was given about discussions in the family. In paragraph 61, the judge referred to evidence from Vacar that while in his room in Cromwell Hospital in December 1991, an agreement was reached by all the family that the court cases would be discontinued and withdrawn, and no further action would be taken by any of the family members. And paragraph 62, he said that evidence was confirmed by Ilyas Malik, the youngest son, and paragraph 63, he says that version is disputed by Iftikhar. After that, he summarizes the different versions from the two brothers as to what had happened after 1991, 1992 or 1993. But as he said, there was little between them. They agreed that by one means or another, it had been agreed that Bilal, the father, would be given authority to resolve the dispute. But paragraph 70 is important, because I could just ask the court to look at that. He says, about 4 lines down, there remains one fundamental issue between the parties, which is what was to happen to the proceedings in England. This is because Vacar's evidence is that the agreement in the Cromwell Hospital included a term that they should be discontinued or withdrawn, whereas Iftikhar says there was no such arrangement. All that Iftikhar would say is that the arrangement was that the parties would stay their hands in relation to proceedings pending resolution by Bilal. And then he records in paragraph 72 that in May 1999, the matter came back in Pakistan before the Lahore court, and the advocate for Vacar said the parties have settled the matter and he wishes to withdraw the petition. So in January 1999, 12 years elapsed from the date when Vacar and Syra had taken possession of the flat without Iftikhar's consent. So that was the expiry of the limitation period. In April 1999, the rules of the Supreme Court were replaced by the Civil Procedure Rules, and CPR Practice Direction 51A, paragraph 19, imposed an automatic stay on any claim which did not come before a judge by the 25th of April 2000. We have reproduced paragraph Practice Direction 50, PD 51A, and the associated rule, Rule 51.1 in the authorities bundle. Probably not necessary to turn it up, but it is at tab 65 if the court wants to look at it. And we've also reproduced there the Civil Procedure Amendment Rules 2021, or at least the relevant part of them. In 2021, in April 2021, that rule and that practice direction were deleted from the CPR. And the explanatory note said that the deletion was to remove spent transitional provisions. Clearly, the Rules Committee thought that there was no chance that anyone would apply to lift the stay imposed by Practice Direction 51A, paragraph 19, after such a long period. And then going back to the chronology and to Mr. Jarvis's judgment, on page 110, paragraph 82, it says, on 17th of February 2011, Iftikhar made the decision to pay into court out of time £25,000, and on the 16th of March 2011, the 2 application notice referred to at the beginning of the judgment were issued to lift the stays and for summary judgment. So this payment of £25,000 was made more than 23 years after he was ordered to make it, more than 24 years after Vacar and Syra had taken possession of the flat without Iftikhar's consent. Double the limitation period had passed by this time. The summary judgment application wasn't pursued in the end, but the application to lift the stays was and was rejected. And the court has seen that Mr. Jarvis's judgment, he dealt with 3 issues. One doesn't matter, which was argued that there was an issue of estoppel because of the decision of Justice Hussain in Pakistan. We can forget about that. The 2 things that are relevant to my appeal are his decisions on the first issue, which is this suggestion, so evidence by Vacar that there'd been an agreement in December 1991 in Bilal's room in the Cromwell Hospital that the actions should be discontinued. And he dealt with that on page 110 at paragraph 84 under the heading The Issues of Breach of Agreement, all the way through to paragraph 95. And what he said in paragraph 84 is important. At the bottom of the page, the last line, he said, the question then arises, how can the court determine that in these proceedings? If the court were to lift the stay, then it seems to me that one of the problems is that the court would necessarily be saying the proceedings could be continued, and the court would therefore have to make a determination now as to this question of fact. So his decision was, I can't lift the stay unless I'm satisfied there wasn't such an agreement, and I can't decide if there was such an agreement without investigating the facts. And his view on that is set out at paragraph 94. He says he couldn't determine the facts without disclosure, cross-examination, and so forth, and he wasn't going to. So the way he dealt with it was to take it into account in deciding whether to lift the stay. And that is relevant because we invited Mrs. Justice Bacon to take the same approach on the fresh application to lift the stay, which she declined to do.
So what approach did you invite us to take?
To take into account that there was evidence that there had been an agreement to discontinue the 1987 possession action, but it would be wrong to determine that issue. It hadn't been determined. And that if there had been such an agreement, it would be wrong to lift the stay, to take exactly the same approach that Mr. Jarvis had taken.
Which was to treat it as a factor in the
Yes.
overall discussion.
Yes. And her decision, as the court has seen, was that I couldn't rely on Vacar's 2011 witness statement. The third matter he dealt with was lifting the stays, and he dealt with that from paragraph 111 through to paragraph 134. And just 5 points I wanted to
Sorry, what paragraph number?
Paragraph 111 through to paragraph 134.
Thank you.
Just a few points I wanted to pick up from what he said. The first is in paragraph 111, where he refers to the order for the payment of security of costs and said there's no question that Iftikhar decided that he was not going to comply with that order by the 1st of January 1988. So it wasn't an accident or inadvertence or bad advice, it was a decision he made. Over the page to page 118, if I may please. And paragraph 121. There's a heading there, whether the application for relief has been made promptly. And the submission of Miss Tipples, who was appearing for Iftikhar, is that the agreement made that no step will be taken in the proceedings pending the resolution of the interest by Bilal as a sufficient reason to excuse the delay that has taken place, the delay of 19.5 years. I am not convinced by that. It's 10 years since the automatic stay took effect. To consider that an action can be held in abeyance for this length of time is on the face of it extraordinary, but there were, it seems to me, as Miss Mathers pointed out, a number of points in time when Iftikhar should have reacted to the approach which was being adopted by Iftikhar. And then he lists those factors. I won't go through those. But at the bottom of the page, the very last line, he says, it does seem to me that those triggers are matters that one would expect to have at least brought Iftikhar to life if he wished to proceed with these actions. I am not satisfied that he's acted promptly. And that is important because Mrs. Justice Bacon said she was satisfied there were good reasons for most of the delay, but didn't refer at all to what Mr. Jarvis had said on that point.
John Jarvis, Queen's Counsel, didn't make any finding about the length of time during which matters were being left to the father to resolve, does he?
No.
But His Honour Judge Gerald did, didn't he?
Well, no, my lord, he didn't. No.
Right, we'll make up that.
He made I will come on to what Judge Gerald had to say, its relevance in this action, which I suggest is none. And if I'm wrong about that, what he actually found and the extent to which it's relevant to the decision as to whether there was or was not an agreement in December 1991 in the Cromwell Hospital.
Well, it's common ground there was an agreement, not where precisely, but sometime in 1991, 1992, it's common ground there was an agreement, wasn't it, that the matters would be left to the father to try and resolve.
Yes.
And is it common ground as to how long that agreement subsisted?
No.
Right.
Judge Gerald had things to say about that. I will come on to what he had to say. But in summary, my submission is that what he said was not an issue. It was a different action. It wasn't in any way necessary. It was all part of a long section of his judgment designed to show that Vacar had been dishonest in the things he said to the trustee in bankruptcy and to the court. That was the purpose of that part of his judgment.
What's your case on how long it was from 1992 after that the matters were being left to the father to resolve? What's your case on that?
Vacar's evidence before Mr. Jarvis was that his father had made a decision in 2004, and the decision was that the father would leave the flat to Vacar in the father's will as part of the distribution of his estate when he died, and in the meantime Vacar would be entitled to remain in occupation of the flat, had a permanent right of possession, a lifetime rent-free tenancy, I think Vacar described it as. So as far as Vacar's evidence was concerned, the matter had been disposed of in 2004. But of course, Iftikhar disputed anything with that. In paragraphs 124 and 125, Mr. Jarvis says that Ms. Tipples accepted it was her client's decision not to proceed to that stage with the action, and then whether there is a good explanation for the failure. And this was one specific thing the court had to take into account under the then version of Rule 3.9. And Mr. Jarvis's decision is that he's not sufficiently satisfied on the evidence that provides an explanation for this enormous period of delay. So there wasn't a good explanation for the failure. And then paragraph 128, he says in the last sentence there, the prospect of a trial of his issues so long after the event is daunting for any judge. Because although the action had been started in 1987, it concerned events that took place in 1978 and the question of the basis on which the flat had been purchased then. So it's already a long time after the event when the action started. And paragraphs 131 to 134. Paragraph 131, he records that Miss Mathers, who was appearing for the trustee in bankruptcy, it says her about 4 lines down. And submission is that for this action to be tried where the myriad of witnesses are relevant is such that it must be impossible after 25 years for memories of witnesses to be satisfactory. Part of the evidence of this case will relate back to the way the property was acquired, and unfortunately there were few contemporaneous documents that exist to support that, or if they do exist, they certainly have not been disclosed at the moment. It seems to me that Miss Mathers' submission is right, but it is common sense that a fair trial issue such as this after 25 years is going to be extremely difficult. And then in paragraph 133, about 5 lines down, he says, a case that is so old as this, where there is such a dispute as to the facts, where all evidence will have to be tested, seems to me to be a paradigm case where it would have been struck out under the old jurisdiction, which of course he's referring to the rules of the Supreme Court and the Alfred McAlpine, Burkitt and James principles for striking out an action for want of prosecution. And then he says, a new jurisdiction brought in by the CPR is one that encourages the getting on with litigation. So that was in 2012. And then as the court knows, in 2018, what's being called the 2017 claim, although it was started in 2018, was started by Iftikhar, claiming possession, and if I could ask the court to go to the core bundle and tab 30, please. This is Iftikhar's reply and defence to counterclaim. And on page 355 at paragraph 8, Vakar's case is as to the basis on which the flat was purchased. Paragraph 20b is being addressed there, which, sorry. In paragraph 20b, it was pleaded by Vakar that the flat was purchased for use as Vakar's home and held on trust for Vakar, and that was denied. And it was said that it was inconsistent with the following, and then paragraph 8.1 is quoted the passage in the transcript of the hearing before Mr. Jarvis where Vakar Malik said, "How can you make an adverse possession claim on property you partly own?" And then page 361, paragraph 26, it was said that Vakar is stopped or otherwise barred because of what he'd said and because it amounted to an express disavowal of any rights in the flat arising by way of adverse possession, and because Mr. Jarvis relied upon that. And in paragraph 27, it was said, in the alternative, to the extent that Iftikhar's claim for possession in the Part 20 claim fails by reason of the law of adverse possession, that fact constitutes a material change in circumstance and or new information since the above judgment, which makes it appropriate for Iftikhar to make a fresh application for the stay on the first English action to be lifted. So it was the change of position from Vakar from saying, how can I have an adverse possession claim, to saying, I have got an adverse possession claim, that was said to justify a fresh application to lift the stay. But that wasn't something in the future, that was something that had happened in the defence and counterclaim. And shortly after the reply was served, there was a letter which is in the supplemental bundle at tab 14. Thank you. Sorry. Tab 14. May I invite the court just to quickly read that letter, just to get the sense of what it was about? So the basic point that was being made, Iftikhar, in the reply and in this letter was, well, you said to Mr. Jarvis, you didn't see how you could have an adverse possession claim. Now you're saying you have got one. So that makes it appropriate to revisit the question of the stay on the 1987 possession action. There's various ways we can go about doing that. And then over the next tab is the reply from DWF. And again, can I ask the court to look at that, please? No, it is right that that letter said it would be wrong to make an application to resurrect the 1987 possession action, and I stand by everything that was said in that letter. It was wrong to resurrect the 1987 possession action. But what the letter wasn't saying was, if you're going to make it, if you're going to try and resurrect it, why don't you wait until after the claim is over? You see if you've won or not, and then have another go. If you lose in front of Judge Gerald in the county court, then have another go in the High Court. And Stevenson Harwood didn't reply, saying, well, we're going to wait and see what happens. If we win, fine. If we lose, then we'll have another go in the High Court. And it's my submission, one of the points that we make is that that wasn't an appropriate way to conduct the litigation. It isn't right to inflict successive hearings trying to achieve the same result. I said I would come to Judge Gerald's judgment, and I will do that now. So that's in the call bundle, tab 17. And if I could ask the court to go to page 227, please. Could I ask the court just to remind itself of paragraphs 20, 21 and 22. And then the first sentence of paragraph 23, Judge Gerald said the task of this court is to reach a conclusion as to what, if anything, was agreed or understood on or before the 6th of December 1978 on the basis of incomplete and necessarily incomplete documentary and other information. Mr. Scott Tucker is referred to there. He was the conveyancing solicitor who dealt with the purchase of the flat at a firm called Still Goes. And he was obviously a key witness. And he had died and his conveyancing file had been lost. My learned friends say in their skeleton argument in more than one place, nobody says there wasn't a fair trial. But there are two ways a trial can be unfair. One is it can be conducted unfairly by the judge, and we're certainly not suggesting Judge Gerald conducted the trial unfairly. The other way a trial can be unfair is the way that the concept is used, was used under the Burkitt and James jurisdiction, which is that long delays can make it very difficult to fairly assess what happened in the past. And that is the context in which it is relevant here. And on that basis, this undoubtedly was not a fair trial. It took so long after the events had taken place and after the loss of key witnesses and key documents. So we do say that, understood in that way, it was not a fair trial. Judge Gerald made an assessment on the basis of the evidence that was called. I am obviously not in a position to say that if there hadn't been, a different result would have been achieved, but I am in a position to submit that it is possible that a different result would have been arrived at. One other point, which I will come back to about the judgment, which is convenient to make at this point, is its status in this action, in the 1987 possession action. The things that His Honour Judge Gerald had to decide, and did decide, in order to resolve the claim, create an issue estoppel. And so his decision that the flat was not purchased by Iftikhar, subject to a trust for Vacar, is binding. But his assessment of the evidence is not binding. the things he said about his impression of Vacar as a witness are not binding or relevant in this action. And to make that good, can I ask the court to look at Authorities Volume 2, tab 71. This is Spencer, Bauer and Handley on Res Judicata, now edited by the Honourable K.R. Handley. And although there are a few pages that are copied here, my submission is that one can get everything one needs from paragraph 8.02, which sets out the principles very clearly. And Justice Dixon said in Blair and Curran that judicial determination directly involving an issue of fact or of law disposes once and for all of the issue, so it cannot thereafter be raised between the same parties or their privies. The estoppel covers only those matters which the prior judgment, decree or order necessarily established as the legal foundation or justification of its conclusion. And then if we go to the next paragraph, he says, nothing but what is legally indispensable to the conclusion is thus finally precluded. In matters of fact, the issue estoppel is confined to those ultimate facts which form the ingredients in the cause of action, that is, the title to the right. And then jumping to the next paragraph, in the phraseology of Lord Shaw, a fact fundamental to the decision arrived at in the former proceedings, and the legal quality of the fact must be taken as finally and conclusively established, but matters of law or fact which are subsidiary or collateral are not covered by the estoppel. Findings, however deliberate and formal, which concern only evidentiary facts and not ultimate facts forming the very title to the rights, give rise to no preclusion. That's the essential principle. So it's for that reason that I submit that what Judge Gerald had to say about Vacar as a witness and what he had to say about the discussions in the period 1991 and 1992 are not binding in this action, not relevant in this action.
When you say this action,
The 1987 possession action. This appeal is in the 1987 possession action. The other action is the subject of the other appeal, and subject to what happens in the other appeal in the other action. That action is one in which it was established that Vacar had title by adverse possession to the flat. In this action, which was started in 1987, there can be no limitation defence because the writ was issued within the limitation period. So I now propose to address what we say are the errors of law in the judgment of Mrs. Justice Bacon when she decided to lift the stay on the 1987 possession action after 35 years. The first error we say was made was a failure to assess the breaches of a court order and a practice direction that Iftikhar had committed and the serious and significance of those breaches. If I could ask the court please to go back to the core bundle tab 14.
And please repeat again, because I'm sorry I was making a noise with the files, what you say her first error was.
The first error in our submission is in failing to assess the breaches that Iftikhar had committed of a court order and the practice direction and the serious and significance of those breaches. If I could ask the court to look in the core bundle at page 202. paragraph 145. She says, on the basis of Iftikhar's evidence before me, Mr. Bunby's submissions as to the 3 stages of a Denton analysis are, in my judgment, well founded. Those submissions are on page 130, paragraph 136, page 200. And Mr. Munby accepted that the delay was both serious and significant, but said there were good reasons for all or most of the delay. They set out in Iftikhar's evidence, as well as the detailed chronology of the proceedings in the 2012 judgment. And taking into account all the circumstances of the case, Mr. Munby pointed out that the key new factor that has now been determined the flat is and always was Iftikhar's, and refusal to lift the stay would deprive him of a valuable asset wrongfully taken for him, and handed to Bakar, who was at least as blameworthy as Iftikhar for the delay in the resolution of the dispute. The evidence from Iftikhar was identified in paragraph 138. It was a statement dated the 5th of September 2022, which, as far as the reason for the delay was concerned, adopted earlier statements he had made. Didn't provide any new evidence. It just said, I refer to previous statements I've made which explain the reasons for the delay. And as far as the delay up to 2011 is concerned, those were the witness statements that were considered by Mr. Jarvis. There was no new evidence at all about the period up to 2011. So going back to paragraph 145 on page 202, this is Justice Bacon then says, while there's no doubt there's been an unusually lengthy delay in applying to lift the stay of the 1987 proceedings, the blame for that delay is not to be ascribed solely or even predominantly to Iftikhar, but lies at least equally with Bakar. So that is one point which I will come on to because we say that was an error. Bakar's proceedings were issued shortly after Iftikhar's, and the progress of the 2 proceedings took the course which he'd summarised. And then she refers to a concession made in a previous hearing by Bakar's then counsel about the progress of the partnership action. And then in paragraph 146, she addresses the delay after the 2012 hearing. Paragraph 147, she deals with the question of the fact that the application to lift the stay wasn't made until after judgment in the 2017 claim, and says that was a reasonable thing for Iftikhar to do. Paragraph 148, she says that Mr. Munby is correct to say that things have changed since the 2012 hearing because it's now been determined that the flat belonged to Iftikhar from the outset. And although Mr. Jarvis thought there wouldn't be an adverse possession defence, there was one. And she says rightly at the end of paragraph 148 that the adverse possession claim can only be relied on in the 2017 proceedings, but not the 1987 proceedings. And then she says there'll be a deprivation of a valuable property. So those are her reasons. It is right to say that she accepted a submission made by Mr. Munby that the delay was both serious and significant, but in our submission that is insufficient, at least in a case of this kind. If I can ask the court to go to the authorities bundle at tab, the first volume of the authorities bundle at tab 37, please. No, that's not right. Must be the second volume, sorry. I wrote down 1, but it isn't 1. It's 2, volume 2. With apologies to taking the court to what I know will be a familiar authority, there is just one point I want to make by reference to it. On page 3937 of the report. Paragraph paragraph 35 in the joint judgment of Lord Dyson, Master of the Rolls, and Lord Justice Voss. Paragraph 35, the court says that the court must, when considering all the circumstances of the case, so as to enable it to deal with the application justly, give particular weight to the two important factors. In doing so, it will take account of the seriousness and significance of the breach, which has been assessed at the first stage, and any explanation, which has been considered at the second stage. The more serious or significant the breach, the less likely it is that relief will be granted unless there's a good reason for it. Now, under the heading, the first stage, Lord Dyson and Lord Justice Voss repeatedly talk about an assessment of the seriousness and significance. And that could perhaps be interpreted as meaning it's either serious and significant, yes, or it's not serious and significant, no. That's all you have to do, work out whether it is one or the other. But it's clear from paragraph 35 that that's not what is meant by an assessment of the seriousness and significance. What's meant is working out how serious it is, how far did the party seeking relief from sanctions depart from what they should have done, and how significant is it, what effect did it have? And the more serious or significant the breach is, the less likely it is that relief will be granted. And in my respectful submission, Mrs. Justice Bacon did not do that. All she did was accept a submission that had been made was that the delay was serious and significant, and leave it at that. And that was an error. I do accept, having reviewed what my learned friends have said in their skeleton and reviewed the judgment, that she did have the whole period of 1987 to 2022 in mind. I was wrong about that. That must be right, because she said that the blame for the delay lay equally with Vacar, so that must go back to 1987. But I do say that she failed to make any assessment of how serious or how significant the Iftikar's breaches were. As to seriousness, we say that to remain in continuous breach of a court order for more than 23 years is as serious as it gets. And as to significance, the delay was enormously significant for reasons we've seen in Judge Gerald's judgment. It led to the loss of key witnesses and documents, the fading of memories, serious impact on the ability of the court to conduct a fair trial.
But the court had by then determined.
I'm sorry, my lord.
The court had by then determined in a trial. You say it was unfair, but there's no appeal against the decision of Judge Gerald on the basis it was an unfair trial, is there?
No, my lord, because the only way there could be an appeal against an unfair trial is if a judge had conducted the trial unfairly. You can't appeal a judgment by saying, well, if it had happened earlier, there might have been different evidence. And that wouldn't be a ground of appeal. The way delay causing unfairness is dealt with is by not allowing the trial to take place, not by having the trial and then appealing it. Once the trial's happened, the judge has to do the best he or she can with the evidence that is available. And my submission is that the trial was conducted fairly, but it was an unfair trial because of a long delay before it took place.
And you're saying, therefore, when looking at, excuse me, significance, despite the fact that the trial had taken place in front of His Honour Judge Gerald, Mrs. Justice Bacon should have seen the delay as significant because, you say, it created that unfairness, as you call it, in relation to that decision which had been made.
Yes. My submission is that when the concept of a fair trial is being used, not on an appeal, but in the context of what should the court do where there's been delay, the assessment is not can a judge do as good a job as they can based on what's available. The question is, has the delay impeded the ability of the court to get as close as it can to the right answer because of the loss of memories, loss of documents, things of that sort? That's the sense in which I'm using fair trial. It can have a different meaning, of course. A judge who interrupts counsel and won't let witnesses finish with their answer, that sort of thing is unfair, but in a completely different sense. So that's the first error. The second error in my submission is that Mrs. Justice Bacon wrongly failed to have regard to Mr. Jarvis's decision in determining that the first and second breaches, that there was a good reason for Iftikhar not complying with the court orders So, I mean, the two things that Iftikhar was in breach of were Master Munro's order in December 1987 to pay £25,000 into court by January 1988, and the requirement implicit in practice direction 51A paragraph 19 to bring a case before the court by May 20, sorry, I'm getting mixed up here, by May 2000. All these events are so long ago. So those are the two things he should have done and didn't do. He should have paid the money into court, and he should have brought the case back before the court at latest by May 2000.
And you're saying Mrs. Justice Bacon's error was to fail to take those things properly into account.
She said there was a good reason.
Yeah.
That's at the second stage of the Denton test. I say she made an error at the first stage, and then moving on to the second stage, she said there was a good reason for most of the delays. And as the court has seen, one of the factors in CPR Rule 3.9, as it was at the time that Mr. Jarvis made his decision, was whether there was a good explanation for the failure to comply with the order or practice direction. So it's something that Mr. Jarvis had to specifically consider and did specifically consider, and he said there wasn't. So a judge of the High Court had determined in this action that there was no good explanation for the delay up to March 2011. Mrs. Justice Bacon doesn't even refer to that. There was no additional evidence, as I've already pointed out, which could have justified her taking a different view. In asserting that there was a good explanation for his breaches of the 1987 order and of PD 51 paragraph 19, Iftikhar relied on the witness statements he'd made back in 2011, which Mr. Jarvis had considered. And so we say it can't be right for if a judge of the High Court considers an application to lift a stay, makes an express finding that there's no good reason for delay, and then that's in 2012, and then in 2023, another judge of the High Court says, well, there was a good reason for the delay, without even referring to what the first judge said on the subject.
What is the status of a first failed application to lift a stay if the same party comes back a few years later and tries again to lift a stay?
Well, in our skeleton argument, we said it was a decision on a specific issue, namely whether there was a good reason for the delay, made after considering evidence and argument, and therefore applying the law as summarised in Spencer Bauer. It does create an estoppel between the parties.
That's the issue about whether there's a good reason for delay, not the overall conclusion not to lift the stay.
Yes.
But what's the overall conclusion, effect of the overall conclusion not to lift the stay? Are you limited in coming back a second time to showing a change in circumstances? If you rely solely on the same matters as were relied on first time around, can you do that?
Well, my submission would be no. My submission would be that would be regarded as an abuse of the process of the court to come back and run the same arguments based on the same evidence again. No court could or should countenance that. So even if there isn't strictly speaking an issue of estoppel, it should not be permitted. It would not be permitted.
But then on each, it depends, I suppose, on how the judge expresses him or herself at the first stage on the issue, good reason, good explanation of delay. But whatever conclusion the judge reaches about that at the first stage, that's merely a factor to throw into the balance in the third stage, isn't it? So unless the judge has made it very clear, well, is it ever possible for a judge to reach a final conclusion on an issue which is then merely part of a balancing exercise?
Well, my learned friends in their skeleton say that if there's one factor in an exercise of discretion, that can't create an issue of estoppel. I haven't found any authority either way on that point, and my learned friends, I'm sure if they had, they'd have cited it. So my submission is it isn't necessary to answer the question, because even if it isn't an issue of estoppel, it can't be right, applying the overriding objective, to allow a conclusion of a judge to be reviewed by another judge based on the same material, inviting the second judge to arrive at a different conclusion without anything new. And of course, there had been a new factor between 2012 and 2022, which is the decision that the flat was Iftikhar's. But that doesn't have any bearing on whether there was a good reason for the delay. Iftikhar had always said it was his flat. But even if I'm wrong, even if it is permissible to seek to persuade a second judge to disagree with the first judge in a situation like this, at the very least, the second judge must surely have to take into account what the first judge said and explain why they're disagreeing with it. And Mrs. Justice Bacon did not do that. So the next error in my submission is Mrs. Justice Bacon said that Vacar was equally to blame for the delays. She said the delay in applying to lift the stay on the 1987 possession action, which is the delay we're concerned with, was not to be ascribed solely or even predominantly to Iftikhar, but lies at least equally with Vacar. And she referred to what Judge Gerald had said, a passage in a judgment of on the Judge Gerald in 2019. That is in the supplemental bundle at tab 17. This judgment was given on an application made by Vacar and his two sons to strike out the Part 20 claim for possession on the footing that it was an abusive process. And it was in, if I can ask the court to look at page 141, paragraph 14. That explains the basis of the application. It has been said that delay, if it's long enough and protracted enough, can itself be an abuse of process, sufficient to prevent somebody from starting again with a new action. And that was the essential argument here. Mr. Halkerston in his skeleton argument and arguments before me to the effect that the Part 20 claim should be struck out as an abusive process because it's now not possible to have a fair trial. And then there was reference to the fact that Bilal had died after the 2012 order. And then at paragraph 16 is a concession made by counsel for Vacar at that hearing for the purposes of that hearing, not a general concession for all purposes. Mr. Halkerston has very sensibly taken the approach that in this case it is very difficult to say that one brother has been more at fault than the other brother in terms of the prosecution of their respective actions, both brought as they were in the same month as 1987. For whatever reasons, they allowed their disputes to go to sleep such that they were automatically stayed in April 2000. And when there was an attempt by the first defendant to revive the matters and have their underlying disputes resolved, that was vigorously opposed by the second defendant. And since then, both brothers have again allowed the matter to become dormant, even though it's self-evident they remained in dispute. And then in paragraph 17, he says it cannot be gainsaid, but it will be difficult to have a fair trial, in the sense that all of the material which could have been available either in 2012 because father has since died or before because mother had died in 2004 and a key conveyancing solicitor or tax solicitor familiar with matters in 1987 had not only died some time, I think in 2001 or 2002, but also the documentation relating to that appears to have somehow disappeared. That's Mr. Scott Tucker again. And then in paragraph 20, Judge Gerald said, it comes to the central point in the case, which is what is the consequence of me striking out the Part 20 claim? Simple answer to that is a mixture of stalemate and checkmate. The reason why it is stalemate is because there would have been no resolution of the issue between the brothers, which has been going on for at least 30 years. When asked of the practical consequences if the Part 20 claim was struck out, Mr. Holkerston was unable to give any indication as to how this dispute could be resolved. So that was the essential problem that the judge saw. And at the bottom of paragraph 22, the judge said that the application to strike out the Part 20 claim must be dismissed. To do otherwise would be tantamount to the court abdicating its function of resolving disputes between the parties. And on page 145 at paragraph 28, he repeats that point. The central reason for refusing to strike this claim out is it would be unfair and quite wrong to leave the parties, specifically the Part 20 claimant, the first defendant, in a position of never-ending stalemate and checkmate. So that puts what Mr. Holkerston is recorded as saying in paragraph 16 in context. It was necessary, Judge Gerald said, for the court to decide the issues that were raised by the 2017 claim, which were whether the flat had been bought by Iftikhar for himself or bought with family money for Vacar, and whether Vacar had acquired title by adverse possession, because if those two issues remained unresolved, there would simply be a stalemate. Nobody would know who the owner of the flat was. So that's what that judgment was concerned with. But in my submission, that has no bearing on the question of whether to lift the stay on the 1987 possession action. That isn't necessary to prevent stalemate, because the issues between the parties have been resolved. Subject to my learned friend's appeal in the 2017 claim, it has been determined that Vacar has acquired title to the flat by adverse possession. The fact that Vacar did not progress the 1987 partnership action is, in my submission, irrelevant to an assessment of what breaches Iftikhar committed of orders and practice directions, and how serious and significant they were in the context of an application by Iftikhar for relief against sanctions imposed on him for those breaches. And in any event, Mr. Holkerston was wrong. Vacar didn't progress the 1987 possession action, 1987 partnership action. Mr. Jarvis refers to difficulties in service, but unlike Iftikhar, he was not in breach of any court order or any rule or any practice direction during the limitation period. The first time he was in breach of a practice direction was when practice direction 51, paragraph 19, required that matters be brought before the court by the 25th of April 2000. It's April 2000, not May, I apologise. So at that point, he was in breach of a practice direction, but by that time, the limitation period had expired. So it's simply not right to say that the delay during the limitation period, the delay at the earliest part, which is the one that matters, or certainly matters most, was equally the fault of Vacar and Iftikhar. It wasn't. His failure to comply with the practice direction would be highly relevant if Vacar was applying for relief from sanctions. But he isn't. He hasn't. He doesn't need to. He was in possession of the flat, and he'd remain in possession of the flat unless and until Iftikhar obtained an order for possession. And in my submission, if Iftikhar wanted to recover possession, it was incumbent on Iftikhar to progress his claim for possession, not incumbent on Vacar to progress his partnership action. Vacar is not claiming title to the flat based on the partnership action. He's claiming title to the flat based on the fact he was in possession of it without Iftikhar's consent for far longer than the limitation period. Another point on this is that if it were right that the blame was equally that of Vacar, then that would have been an important factor in 2012 just as much as in 2023 or 2022. And Mr. Jarvis clearly didn't think it was right to lift the stay So again, there's a failure to take into account Mr. Jarvis's judgment. One point that my learned friends make in their skeleton argument is that Vacar was not permitted to let sleeping dogs lie and allow a limitation defence to accrue. And in my submission, that is not right. Let's look at the first authority that my learned friends rely on, which is in volume 1 of the authorities at tab 19. Case called Asian Sky Television against Bayer Rosin, decided in November 2001. And the passage that my learned friends rely on is on paragraph 48, page 332. It is no longer appropriate for defendants to let sleeping dogs lie, CF Allen against McAlpine, Sir Alfred and Sons. And the key words there are no longer. What Lord Justice Clark was saying was, under the rules of the Supreme Court, it was appropriate for defendants to let sleeping dogs lie. That's exactly what the Court of Appeal held in Allen against McAlpine. Lord Justice Tiplock in that case specifically said that a defendant is entitled to let the action go to sleep and to take advantage of the expiry of the limitation period. What had changed with the CPR was that that was no longer appropriate. The defendant cannot let time go by without taking action and then later rely upon the subsequent delay as amounting to prejudice and say that the prejudice caused by the delay is entirely the fault of the claimant. Such an approach would be contrary to the ethos underlying the CPR, quite apart from being contrary to paragraph 2.7 of the Part 23 Practice Direction. That was concerned with prejudice rather than limitation. But it wasn't the case that when the CPR came in, that was projected backwards, as it were, into the past. And it was also not the case that the CPR allowed a more lenient approach to delay than the rules of the Supreme Court. If I can ask the court to go back to paragraph 42. There's a quotation there from Lord Lloyd in a case called UCB Corporate Services in Halifax. It would indeed be ironic if, as a result of the new rules coming to force and the judgment of this court in the Baguzzi case, judges were required to treat cases of delay with greater leniency than they would have done under the old procedure. I feel sure that cannot have been the intention of the Master of the Rolls in giving judgment in the Baguzzi case. What he was concerned to point out was that there are now additional powers which the court may use and should in the less serious cases. But in the more serious cases, striking out remains the appropriate remedy, where that is what justice requires.
The context of this case was a complaint of prejudice caused by delay.
Yes.
And the point is made, well, you can't really complain about prejudice in delay if you yourself have acquiesced in that delay.
Yes.
So it's different, isn't it? If there was as a result of delay, you've quite legitimately extinguished someone else's title to land which you possess. Is there any case where this principle's been applied in an adverse possession context?
Not as far as I'm aware, my lord, no. The other authority that's cited by my learned friends on this is in volume 2 of the authorities at tab 46. With apologies if I'm mispronouncing their name, this is called Quaradigini against Mishkon de Rea. decision of Mr. Marshall, QC, sitting as a deputy. Page 34 of the law report. Oh. What's happened here? Sorry. I seem to have two copies of it. Obviously, entirely my fault. I do apologise. Just give me one moment. I didn't notice that before. Right. Yes. Paragraph 10 is what I'm after. That's on page...
Under relevant principles.
Yes, thank you. It is page 34, actually. Yes, thank you. Relevant principles, paragraph 10. The Deputy Master appears to have proceeded to strike out the claim on the basis of principles derived from the House of Lords decision in Grovet and Doctor and others. And then in paragraph 11, the Grovet case preceded the introduction of the civil procedure rules and concerned an application to strike out when the old doctrine of want of prosecution based on principles set out in the speech of Lord Diplock in Burkitt and James still applied. And then in paragraph 13 on the next page, there's a quote from Lord Wolfe. If I could just ask the court to look at the second of the two paragraphs there, please. And the second sentence, defendants do not need to wait until there's been an inordinate delay before applying for preemptory orders, although they are under no obligation to do this. And that was the approach of the court under the rules of the Supreme Court. The defendant didn't have to bring matters before the court. The defendant was perfectly entitled to let time go by and take advantage of the accrual of a limitation period. Things were different under the CPR, and Mr. Marshall says that in paragraph 16. He says the observation of Lord Wolfe in Grovet that a party could apply for an unless order to prevent delays but was under no obligation to do so is also now subject to qualification under the current procedural regime. It is now incumbent on the party to apply for relief, including a preemptory order, as soon as reasonably practical, if they wish to seek such relief in respect of delay. And then he quotes from Lord Justice Clark in Asian Sky. Also relevant on this point, my submission is another case, which I'm afraid is in the other volume 1 of the authorities, tab 23. This is a decision of the Court of Appeal in a case called Audigan and La Baguette Limited, and it concerned an action started in May 1996 in relation to events which were alleged to have occurred in 1993, and there were delays in prosecuting the claim, and it became stayed under Practice Direction 51, paragraph 19. And after the stay had applied, the claimant applied for permission to amend the statement of claim. Master Weingarten refused to lift the stay. On appeal, Mr. Justice Reimer decided to rehear the application and made a different decision. And the Court of Appeal then said that the judge shouldn't have conducted a rehearing. Instead, the judge should have conducted a review. The Court of Appeal then conducted its own review and agreed with the Master's decision, upheld the Master's decision. It went a bit further than that. If I could ask the court, please look at page 12, or the bolder numbers are the bundle numbers. It's probably easier to use those, page 488.
What's the paragraph in the decision?
Paragraph 34. Sorry, paragraph 34. I just ask the court to look at that. This is the note of the hearing before the Master. Court will readily lift a stay if the case is such as has not already gone to sleep for such a long time that the court would strike it out under the old rules for want of prosecution. That was how he directed himself. And then in paragraph 35, the rest of the note of his judgment is set out, and at the bottom of that page, the last paragraph, he said, "I'm satisfied on balance that despite the existence of affidavits about the dispute, because the nature of the whole arrangement or scheme was oral, it's now going to be difficult to hold a fair trial. Therefore, I will not therefore stay, and I would have acceded to the request to strike out the statement of claim." So that was his decision. And then on page 515, paragraph 110. Lord Justice Jonathan Parker says the next question is whether the Master's decision not to lift the stay was wrong, in the sense that it exceeded the generous ambit within which reasonable disagreement is possible. And then he says, I agree with the judge that, as the Master himself indicated in the course of the judgment, the question whether the stay should be lifted and the action allowed to proceed was one which different minds might reach differing conclusions. He says, nor in my judgment can it be said that in reaching his decision the Master took into account irrelevant matters, or that he failed to take into account relevant matters. The Master rightly addressed himself to the central question, whether, given the substantial delays which had occurred, it was still possible to have a fair trial of the action. His conclusion that it would be difficult to have a fair trial, but on balance the stay should not be lifted, seems to me to be unassailable on appeal. And then in paragraph 113, he said, I should add that had I been in the position of the Master, I would have reached the same result he did, save only that in the interests of procedural tidiness, I would have ordered the action be struck out rather than allowed it to remain stayed sine die. In my judgment, this is a plain case in which the substantial delays on the part of Mrs. Algdon have placed such a difficulty in the way of a fair trial of the issues which she seeks to litigate for justice requires that the action should not proceed further. So there was no suggestion there that in this case, which had been conducted under the rules of the Supreme Court, the defendant should have brought the matter forward and couldn't take advantage of the delay in the expiry of the limitation period as a result to get rid of the action. The next error that we submit was made by Mrs. Justice Bacon was a failure to have regard to the fact that the order lifting the stays deprived Vacar of his title to the flat, and the policy of the Limitation Act 1980. If I could ask the court to look at Authorities Volume 2, please, at tab 68A.
Yes, sorry.
This is the current edition of McGarry and Wade on the Law of Real Property 2024 edition. And it's repeating things that have been said going all the way back. Paragraph 771 says the general character of a title to unregistered land acquired by limitation has already been discussed. The squatter holds a new legal estate founded on adverse possession and the absence of any better title, but holds it subject to any third-party rights which run with the land and have not themselves been extinguished. And then on paragraph 772, they say a squatter's estate is normally a fee simple absolute, though it may be cut down by the unextinguished rights of other persons. So when somebody takes possession of land without the consent of the owner of the land, their possession gives them a title to the land, and that title is, absent special circumstances, a fee simple absolute in possession, and it is the best title apart from the title of somebody who has a better title. and can be asserted against anybody. And that's made clear in a case in Volume 1, tab 6, Powell and McFarlane. So Authorities, Volume 1, tab 6, page 476 of the law report. And this is a judgment of Mr. Justice Slade. And could I ask the court to have a look at the paragraph beginning about 5 lines down, beginning with the words, "In my judgment, it is consistent."
So what page are we on?
This is page 476 of the law report, page 90 of the bundle.
Thank you.
So,
Sorry, just give me a second. I had a
sorry, my lord.
crash there. Just give me pick up the document again. Yes.
The old saying that possession is 9/10 of a law has considerable truth in it, because once a person has taken possession of land, then they are, for all purposes, the owner of it, except against somebody who has a better right to possession of the land, and they can repel trespassers, as Mr. Justice Slade says. And the function of the Limitation Act is to set a time limit for somebody who has a better right to possession of land to enforce that right. It's a 12-year time limit. And the policy underpinning that has been explained in a number of cases. If I could ask the court to look first at tab 15 in volume 1. This is the decision of the Court of Appeal in J.A. Pye and Graham. And their decision on the assessment of the evidence was reversed by the House of Lords. But the part I want to look at isn't concerned with that. It's concerned with the question of whether allowing somebody who's in adverse possession of land to acquire title infringes Article 1 of the first protocol of the Human Rights Convention, and therefore does Section 3 of the Human Rights Act require the Limitation Act to be read down. And it's in that context that Lord Justice Mummery on page 822 of the law report just above letter B, where the red sidelining is, even if contrary to my view, that convention right potentially impinges on the relevant provisions of the 1980 Act, those provisions are conditions provided by for law and are in the public interest within the meaning of Article 1. Such conditions are reasonably required to avoid the real risk of injustice in the adjudication of stale claims, to ensure certainty of title and to promote social stability by the protection of the established and peaceable possession of property from the resurrection of old claims. And some of those are applicable to all limitation periods. Most of the Limitation Act is concerned with claims to recover debts or damages for various causes of action. But land, the recovery of land raises different issues, because land is unique, unlike money. And what Justice Mummery is saying in my submission rightly is that part of the function of the limitation period is to protect people who are in possession of property from being deprived of that possession, even by somebody who has a better right, if the person with the better right has not enforced it for a sufficiently long period. If I could ask the court to look in tab 31, please. Just the one sentence on page 692 of the bundle, paragraph 19 of the judgment. This was a case about abuse of process, where somebody who'd had a cause of action, or said he had a cause of action, became bankrupt, so his cause of action vested in the trustee in bankruptcy, and then hoping and expecting he'd get an assignment from the trustee, he started proceedings within the limitation period, hoping he'd get an assignment and then carry on, and the Court of Appeal said that was an abuse. So that's the context for the discussion here. Was it permissible for somebody to issue a claim at the end of a limitation period? I think it was the last day of the limitation period, hoping to get an assignment of the cause of action subsequently. That's the context for what Mr. Justice Mann is here quoting from a judgment of Lord Justice May, paragraph 19. And he says that what the learned judge below did not cite was what Lord Justice May went on to say about limitation periods. Good justice needs to be swift justice. In my opinion, the limitation periods provided for by the Limitation Act 1980 are generous. Any artificial extension of those periods needs to be fully justified. And then if I may, just one more authority on this point, which is in volume 2 at tab 43. This is a decision of the Court of Appeal called Nasrullah and Rashid. It was an adverse possession case. And it was one where a fraudster forged a transfer and got registered as proprietor, and he and his son managed to hold on to the title for longer than the limitation period before the owner was able to bring proceedings, and the court held that the delay meant the title had been lost. And if I could ask the court please to look at page 62 of the report, paragraph 72 to 74, one's sidelined in red. I invite the court to read those, please. The point is summarised in the first sentence of paragraph 74. There can be no doubt that bad people are entitled to the benefit of limitation periods. On the findings of Judge Gerald, Iftikhar acquired the flat with his own money for himself and not with family money for Vakar. And Vakar was wrong to say that the flat had been purchased as a home for him. So on that on that basis, he should not have defended the 1987 possession action. although in fact he never served a defence because the stay came into effect. But that does not mean that the policy of the Limitation Act is inapplicable. If Iftikhar had waited until 12 years had passed before issuing a writ, then of course his right to possession would have been lost. And the submission we make is that the same ought to be true in circumstances where he did bring a possession action within the limitation period, but it was then stayed for breach of a court order for longer than the limitation period. And we say this is an important factor which Mrs. Justice Bacon did not take into account. And on this point, we rely on the judgment of Lady Justice Arden in Ofulu and Bossert, which we've referred to quite extensively in our skeleton, but it's in volume 1 of the authorities, tab 29.
So just to be clear, the factor is that if the 1987 claim stay was not lifted, it followed as night follows day, Bakar had established the right by adverse possession.
My Lord, yes. And by lifting the stay and defeating that accrued right, the learned judge said that if she didn't lift the stay, Iftikhar would be deprived of a valuable property. But she didn't take into account the mirror image of that is that by lifting of the stay, she deprived Bakar of a valuable property which he'd acquired title to.
I'm sorry, divided 29.
It's, my lady, yes, tab 29 in volume 1. So I think that the court has seen in the skeleton arguments, the Ofulos owned a house in Bow. Mr. Bossert and his daughter, Miss Bossert, were let into the property by a former tenant. And in 1989, the Ofulos started possession proceedings against the Bosserts. And in their defence, the Bosserts claimed that it had been agreed that Mr. Bossert would be granted a 14-year lease of the property. And they said they were entitled either to a tenancy protected by the Rent Act or to an extrable 14-year lease. That was their defence. And then if I can go to page 12 of the law report, please. Paragraph 23 says that in August 1996, Mr. Bossert died. The Ofulos failed to pursue their proceedings for possession, which were automatically stayed under the civil procedure rules. And in the course of 2001, the Ofulos returned to the United Kingdom and contacted Miss Bossert to request to leave the property. On the 13th of November 2000, the Ofulos served a notice to quit. On the 1st of February 2001, the Ofulos applied to lift the stay, and their application was heard by District Judge Lightman, who on the 16th of April 2002 refused it. It is true that when one reads the report of the case when it reached the House of Lords, it is recorded there that the claim was not only stayed but also struck out. But that is not referred to in Lady Justice Arden's judgment, and we will see from something she said later on that she was proceeding on the basis it was stayed and not struck out. Paragraph 25, Lady Justice Arden records a further notice to quit, the issue of fresh possession proceedings in which the adverse possession claim was raised, and that the trial judge held that the adverse possession claim succeeded. And one of the issues in the appeal was whether that result was unlawful as a disproportionate breach of Article 1 of the First Protocol. And that in turn depended on whether the Court of Appeal should apply the decision of the European Court of Human Rights in J.A. Pi Oxford against the United Kingdom, and the court said that that should be done. And paragraph 55 on page 21 of the law report is in the context of the discussion about Article 1 of the First Protocol. And she says there, the finding of adverse possession in Pye and Graham meant that the paper owner had lost land which was extremely valuable, but that factor was irrelevant. In that case, the paper owners had slept on their rights, In this case, the Ophulus objected to the presence of the Bossets on the property, but they also slept on their rights because they did not pursue the proceedings which they had begun for possession to a conclusion, so as to prevent the completion of title by adverse possession. It is no answer to say that the Bossets represented in their defence that they were tenants, because this was not an assertion the Ophulus were prepared to accept. In the circumstances, I do not consider that special circumstances are shown from departing from the decision of the Strasbourg court. And in our submission, that applies equally in the present case. And if I can ask the court then to go on to paragraph 64. Please. Paragraph 64 is in the context of Lady Justice Arden considering a different issue, which is whether Mr. and Miss Bossert had the intention to possess. They were claiming that they had the permission of the owners to be there in the form either of a tenancy or an equitable lease. Did that mean that they didn't have the intention to possess? And the Court of Appeal said, no, they did have the intention to possess. And in paragraph 64, Lady Justice Arden says, it is moreover clear that the inception of the first set of proceedings would have stopped time running so long as those proceedings were on foot, but not thereafter. And then she refers to Markfield and Evans and BP Properties in Buckler. In my judgment, this principle must apply where proceedings are permanently stayed, as the first set of proceedings was stayed in this case, and Mr. Wilson has not suggested otherwise. So it is quite clear from that Lady Justice Arden's judgment is on the premise that the action was stayed and not struck out. If she thought it was struck out, she wouldn't have needed to say anything more than this is governed by Markfield and Evans, where the first possession action was struck out. So in our submission, the policy underpinning the Limitation Act and the fact that lifting the stay deprived Vacar of his title was an important factor, which the learned judge didn't refer to. And if this factor is taken into account, there is only one reasonable conclusion, which is that it would be wrong to lift the stays on the 1987 possession action. Vacar was in possession of the flat without Iftikhar's consent for more than 12 years after the action was stayed. There was a 15-year period from 1988, when the action was stayed, until, sorry, that's not right. Not 15 years, 12 years after the action was stayed, and throughout the whole of that period, and indeed thereafter, Vacar was in possession of the flat. The action had gone to sleep, and then it was stayed because of the breaches of the order of Master Munro, and because of the breach of Practice Direction 51. In their skeleton argument, my learned friends say it would be disproportionate to deprive Iftikhar of his title because of delay. And they say the most he could have been fined for contempt of court is some modest amount, but that is not a reasonable analogy in my submission. Limitation periods don't operate to punish people. They operate for the reasons we have seen, to prevent the litigation of stale claims and to preserve the peaceful possession of property. It's not to punish the owner. So a comparison with contempt of court, which is all about punishment, is inappropriate. If a person sleeps on their rights by allowing a possession action to be stayed for breach of a court order for more than the limitation period, the law confers title on the person in possession for good policy reasons. In their skeleton, my learned friends also say that I must be submitting that a court can never allow a stay to be lifted if that would undermine a limitation defence. That's not my submission. But I do say that the policy underpinning the Limitation Act should be applied in circumstances where, for a period longer than the limitation period, the action is stayed, at least where it's stayed for breach of a court order. And the policy underpinning the Limitation Act is an important factor, and that's made clear by one of the authorities cited in volume 2 of the authorities bundle at tab 53. This is a case with ST against BAI SA, trading as Brittany Ferries, a decision of this court in July 2022. And I'd ask the court to look at paragraph 58 in the judgment of Lady Justice Carr. The case was concerned with this rule, CPR Rule 7.6, extension of time for serving a claim form. The normal rule, as the court knows, is that a claim form has to be served within 4 months of issue under Rule 7.5. 7.61 says the claimant may apply for an order extending the period for compliance with Rule 7.5. The general rule is that an application to extend the time for compliance with Rule 7.5 must be made within the period specified by Rule 7.5, or where an order has been made under this rule within the period for service specified by that order. If the claimant applies for an order to extend the time for compliance after the end of the period specified by Rule 7.5, or by an order made under this rule, the court may make such an order only if the court has failed to serve the claim form, or the claimant has taken all reasonable steps to comply with Rule 7.5 but has been unable to do so, and in either case the claimant has acted promptly in making the application. And in this case, the ST against BAI case, the application was made before the period for service of the claim form expired, so that 7.6(3) did not apply. So in those circumstances, the rule said nothing. In the case of an application made after the end of the 4 months, there's special provision at 7.63. Where the application is made within the 4-month period, the rule just says that the claimant may apply for an order. But the courts have developed principles to guide the discretion to be exercised under Rule 7.6. And this case was concerned with stating those principles and applying them. And if I could ask the court to read paragraph 62, there Lady Justice Carr summarises the principles. So 2 points which are important. The first is that the rule itself says nothing about the limitation period at all, but the courts have held that the policy of the Limitation Act is a very important consideration in deciding how the court's power to extend time for serving a claim form should be exercised. It's an important consideration. And in paragraph 63, Lady Justice Carr says that in a previous case it was said that a defendant's limitation defence should not be circumvented save in exceptional circumstances. This is a phrase that needs to be approached with care. It's one about which the judge himself expressed reservations. At their outer limit, the words exceptional circumstances can be taken to mean very rare or very rare indeed. In the present case, however, the phrase should not be taken to mean any more than its literal sense, namely out of the ordinary. It means, as identified, for example, in Hoddenot, that the actual or potential expiry of a limitation defence is a factor of considerable importance. The factors in favour of an extension of time will have to be either separately or cumulatively out of the ordinary. So that shows that the policy of the Limitation Act is something that should be taken into account when applying the rules, even if the rules don't themselves refer to it. The Limitation Act itself sets the date by which you have to issue the writ claim form. It doesn't say anything about what is to happen thereafter. But it is clear from this case that the claim form has to be served within the period provided for its validity, and that any departure from that needs to be justified. And in my submission, the same must be true with progressing an action. If somebody issues a writ or a claim form within the limitation period, and then in breach of a court order fails to pay money into court, the action is then stayed, and the limitation period comes and goes, and then another period, as long as the limitation period comes and goes. It simply cannot be a right exercise of discretion to then lift the stay. Absent very special circumstances, as if, for example, Vacar had said to Iftikhar, don't worry about the expiry of the limitation period, and in reliance on that, Iftikhar had done nothing. That would be a special factor. So I'm not saying that it can never be right in any circumstances to lift a stay in circumstances such as those in the present case, but I do say there would have to be something very special, and there is nothing special. There are no special circumstances justifying lifting the stay. My learned friends refer to how the land registry reacted in 2000 when Vacar applied to the land registry, but that is summarised by Mr. Jarvis in his judgment. Really, how the land registry reacted to an application made in 2000 can't be any help in deciding how the court's discretion exercised in 2023 should be exercised. My learned friends also refer to the fact that Mr. Jarvis, after he'd given his judgment, said that he wasn't striking out the action, and he seems to have contemplated that if a new claim was started within a reasonable time and resolved, then somebody might apply to lift the stay in order to have costs dealt with. But nobody asked him to strike out the action. And in our submission, as we said in our skeleton argument, if somebody had asked him to strike out the action, he would have been bound to do so under the law. The principles that applied under the old law are summarised in a case called Arbuthnot, Latham Bank and Trafalgar Holdings, which is in volume 1 of the authorities at tab 13. At page 1431 of the law report. At letter G, Lord Wolfe, Master of the Rolls, after having said the starting point is Burkitt and James, he says the position shortly is as follows. 1, an action should only be dismissed for want of prosecution where the plaintiff's default has been intentional and contumelious, or where there has been inordinate and inexcusable delay giving rise to a substantial risk that a fair trial would not be possible or to serious prejudice to the defendant. 2, before the limitation period has expired, an action will not normally be dismissed for inordinate and inexcusable delay if fresh proceedings for the same cause of action could be initiated. And then page 1432, to C, Lord Wolfe said that in Burkitt and James, the House of Lords also explained why whether the limitation period has expired is so significant. The reason is that in the absence of some conduct which means that a second action could be stayed, it would not benefit the defendant to have the first action struck out, since this would only result in further proceedings which would inevitably cause more expense and delay. If, however, the limitation period has expired, the same logic does not apply. It also does not apply where the defendant to the fresh action is able to show that it's open to doubt and serious argument whether the cause of action asserted would be time-barred if fresh proceedings were issued. In such circumstances, the interests of justice may be best served by dismissing the action and leaving the party whose action has been struck out to bring fresh proceedings if he chooses to do so. So those were the principles under the rules of the Supreme Court. And Lord Wolfe later made it clear in a passage on page 1436. The courts were less tolerant of delay at that time in 1998 with the civil procedure rules on their way than they had been in the past. So in our submission, given what Mr. Jarvis said this would have been a paradigm case under the old jurisdiction for striking out. He was 100% right. And if somebody had asked him to strike out, he would have been obliged to strike out under the principles that applied.
But he wouldn't, would he? Because Lord Wolfe said in the passage he showed us that where the limitation period hasn't expired, it would not usually be right to strike out because you can always start again to strike out.
Yeah.
That was the position before Mr. Jarvis, wasn't it?
Well, in 2012, the limitation period had expired long ago.
Had it?
Yes, the limitation period started to run in January 1987 and expired in January 1999.
Only to the extent that someone was in adverse possession for that period.
Yes.
But Mr. Vacar was not saying he was in adverse possession before Mr. Jarvis, was he?
No, but my submission is that if Mr. Jarvis had understood that there was an adverse possession defence, then it would have been an appropriate case for striking out.
Well, okay. If there had been one,
Yes.
he understood it.
No, well, the trustee in bankruptcy said, I have an adverse possession claim I wish to make, and therefore I would like the current claim to remain stayed, so that Iftikhar has to start a new claim. And in that new claim, I will assert adverse possession. That's what the trustee in bankruptcy had said in his witness statement before the hearing. Sarah's solicitors had written saying she was going to rely on adverse possession. And what happened at the hearing was that Vacar said, I don't see how I can have an adverse possession claim since I'm a part owner. He said Sarah would have an adverse possession claim, and the judge said, well, no, she wouldn't, because she says she was there with the permission of the true owner. And he clearly was of the view, which other judges have shared, that if you say or believe that you're there with the permission of a true owner, you're not in adverse possession. But that wasn't correct in my submission. We'll deal with that in the appeal, in my learned friends appeals, but certainly at first instance, it is, I submit it's settled, not at this level, but at first instance it is settled that a person who is in control of land for their own benefit, but who says or believes that they have the owner's permission, does have the intention to possess. So I probably haven't put this very well, my lord. Of course, based on what Mr. Jarvis understood, he wouldn't have struck out the action because he thought there wasn't any limitation issue. But if he correctly appreciated the position, he would and should have struck it out. That's how I should have put it. I'm very grateful to your lordship's help. We're going to get that right. The next error we say was made was Mrs. Justice Bacon's decision that it was perfectly reasonable for Iftikhar to wait and see what happened in the 2017 claim before applying to lift the stay. That's what she said in paragraph 147 of her judgment. Where a person has two claims, they're generally required to bring them forward at the same time, although there can be special reasons not to. It's in the public interest that there be finality in litigation, and that a party shouldn't be twice vexed in the same matter, and that there should be economy and efficiency in litigation. These are familiar principles, and I don't suppose I need to spend much time on them. There's a passage in the White Book that summarises the position. That's in volume 2 of the authorities, tab 72. And page 96. There's a heading above paragraph 3.4.5, attempts to relitigate issues which were raised or should have been raised in previous proceedings or earlier in the same proceedings. And then at 3.4.6, attempts to raise issues which should have been raised in earlier proceedings, the rules in Henderson and Henderson. I won't go through that because I'm sure the court is very familiar with that rule and how it applies. And then on page 97, about halfway down, there's a paragraph beginning with the words, however, it is not necessary for there to be two different sets of proceedings. And then at the bottom of the page, in that context, the editors say, in Seal Austria and Tokyo Marine Europe Insurance, Mr. Justice Coulson, as he then was, said this: the court should be astute to prevent a claiming party from putting its case one way, thereby causing the other side to incur considerable expense, only for the claiming party to lose and then come up with a different way of putting the same case so as to begin the process all over again. Civil procedure rules are designed to avoid the litigation equivalent of death by 1,000 cuts. And in my submission, that is exactly what we have here. We have Iftikhar saying, I'll have a go in the county court. If I win, that's great. If I lose, I'll have another go in the High Court by issuing an application to lift for stay on the 1987 possession action. It's suggested by my learned friends in their skeleton that Vacar should have made an application to the court for a direction that the application to lift for stay should be heard together with the 2017 claim. My submission, that is not a realistic submission. The court has seen the exchange of letters between Stevenson, Harwood and DWF. Stevenson, Harwood said, we reserve our right to do it. DWF said, you shouldn't do it because you'll lose. And then nothing more happened. It was certainly incumbent on Iftikhar, if he wanted to make this application, to make it before the trial and judgment in the 2017 claim and not after. The next error in our submission that Mrs. Justice Bacon made was in failing to have regard to the factors specifically mentioned in Rule 3.9. She didn't specifically refer to the special factors that we've been told have to be given particular weight. She only referred to her assessment of what she thought the justice of this individual case required, namely enabling Iftikhar to recover a valuable property. And what she did, we submit, is to give preeminence to the merits of the claim, which in Denton and Mitchell was said to be wrong. So those are the 6 points that we have on Mrs. Justice Bacon's decision to lift the stay as a matter of her discretion. We then have some points in relation to her decision that she wasn't going to allow Vacar to rely on the witness statement he'd made in 2011. The court has seen how Mr. Jarvis approached that matter. What is clear from Mr. Jarvis's judgment is that no one was suggesting to him what had been agreed in 1991 or any later date precluded a new claim from being started. The argument was only that the existing claims were to be discontinued. Vacar's witness statement, which he wished to rely on before Mrs. Justice Bacon, is in the supplemental bundle at tab 4. And paragraph 3. In 1991, an agreement was reached that all disputes relating to this matter will be settled within the family. Mr. Bilal Malik, the father, was seriously ill, and it was resolved by the family that all the court cases will be discontinued or withdrawn, and no further action will be taken by any of the family members in relation to this matter. This agreement was reached in the Cromwell Hospital room in the presence of, and then he lists the people who were there.
You say it wasn't the case before Mr. Jarvis that no further action was precluded, but isn't that exactly what Vacar's evidence says? Discontinue or withdraw the original actions, and no further action will be taken by any of the family members in relation to this matter.
That doesn't say permanently, my lord. It doesn't say a permanent bar. And in terms of what's the hearing, how the hearing before Mr. Jarvis was conducted and what points were being made, one has the transcript and one has his judgment. He certainly didn't see any problem in a new claim being started because he contemplated that one would be. He did see a problem in lifting the stay on the existing one, so certainly as he saw it, what was this agreement, which is the one he was referring to as potentially problematic, would potentially preclude reviving the 1987 possession action, but wouldn't preclude a new claim. I'm not sure I can say much more on the point than that, my lord. I can see your lordship's point that no further action will be taken by any of the family members in relation to this matter. That could be read as meaning will never be taken. It could also be read as meaning for the time being we'll stop the existing ones, we'll try and settle this. But that's not the same as saying if we can't, then there will never be any further litigation between members of the family. My submission that must be how Mr. Jarvis understood it, and indeed how it is to be understood. And then he said in paragraph 4, it's for this reason that the court cases in Karachi were discontinued in 1991 and no further action was taken in terms of the revision petition, the appeal, in Lahore until 1999 when the suit was withdrawn on the basis that an out-of-court settlement had been agreed. This out-of-court settlement was made in 1992, and I'll refer to this later. It's for this reason that no further action was taken in the London court cases. And then he says in 1992 an agreement was reached within the family that upon the undertaking of the father that all of the family estate will be distributed equally among his legal heirs. It was acknowledged that as the founder of the business, the father was the beneficial owner of all of the properties, including the flat in London, and a document was signed. The document doesn't in fact refer to the flat, so it may or may not have included the flat, but certainly Bakar said it did. And then in paragraph 7, he said, upon the death of my mother in June 2004, the father had resolved the family disputes along the following lines. And then 9.1, the father was the beneficial owner of all the family partnership property, including the flat. All the family agreed. All the cases between the family members would remain discontinued and no one would have any right of action in relation to the old family dispute. At that point, what was said in June 2004, that would that would amount to an agreement that there would be no further claims either. But Mr. Jarvis didn't seem to regard that as an issue. And then just to see what the agreement was, in 3 it says the flat at Knightsbridge will be given to myself as part of the inheritance share, and 4, my family and I will continue to reside in the flat as my permanent home. So that was his evidence about settlement. An agreement was reached for discontinuance in December 1991. In 1992 it was agreed that the Bilal would get to decide, and in June 2004 the father did decide. Sarah said in her witness statement, tab 5, page 64, paragraph 15 is her evidence. In 1991, my father-in-law was seriously ill, and my husband agreed with my father-in-law and his family that all the court cases would be dropped and the family would resolve issues outside the court. This meeting took place in the hospital room at Cromwell Hospital, and then she lists the people who were there. And at the end she says, my father-in-law phoned his lawyer in Karachi telling him that all the cases would be dropped and instructed Iftikhar Malik to drop the case in London as well. So certainly her evidence about it, if it were correct, would suggest it was an agreement to stop the existing claims, but not one that would necessarily prevent new claims being started. And we know from what Mr. Jarvis said that Ilyas Malik made a statement recording his recollection of this meeting as well, which accorded with that of Bakar and Sarah. Iftikhar said this wasn't right. There was never any discussion in the Cromwell Hospital about staying or discontinuing or anything of that sort. He said the discussions came later. An important point about this evidence, about what happened in the Cromwell Hospital, is that it was not an issue in the 2017 claim. Whether there was an agreement in 1991 for the discontinuance of existing proceedings, or an agreement in 1992 to 1993 that they would be put on hold, which was the difference between Vacar and Iftikhar, had no relevance to the issues in the 2017 claim. And Judge Gerald did not therefore decide that issue. He didn't address that issue. What he did have to decide was whether it was an abuse of the process of the court for Vacar to rely on adverse possession in the light of what he said to Mr. Jarvis. And he approached that by making an adverse assessment of Vacar's character. And if we can look in the core bundle, please, at tab 17, page 238.
Sorry, is this Jarvis's judgment?
So I'm sorry, this is
Sorry, it's
Judge
just
Gerald.
I've got them separated out. The
I'm
judgments.
so sorry, my lady.
So,
It's Judge Gerald's judgment,
thank you.
the main judgment,
Thank you.
2022,
Two.
page 238,
Thank you.
starting at paragraph 80. So this section of his judgment is headed Evidence and Discussion, and starts at paragraph 80 and ends at paragraph 100. This is where he says it is an abuse of the process for Vacar to rely on adverse possession in the 2017 claim. And in paragraph 80, he says the reassurance to the deputy judge that no adverse possession claim would be made. The 1987 claims were struck out, was given 1 year after Vacar had emphatically told his trustee in bankruptcy he did not have any interest in the flat because it was owned by his father. Before considering those statements in more detail, it's necessary to consider Vacar's evidence as a whole, which will show that he's adept at saying one thing but meaning another, or obfuscating sufficiently to satisfy the questioner, avoiding giving simple, straightforward answers. And so what follows is an assessment of his character. And to justify the conclusion that he reaches in paragraph 89 in the last sentence, the statement of a trustee was therefore disingenuous and knowingly disingenuous. That's the purpose of the discussion between paragraphs 80 and 89, to justify that finding. And in turn, that's justified because of the finding he makes in paragraph 85 in the first sentence. It was simply agreed that father was given authority to distribute or determine or resolve the dispute as to ownership and therefore occupation of the flat, but was not actually treated as being the owner. And that if no accepted determination or distribution or resolution was made, then both sons could resume their dispute. And he's making that finding so that he can then say, when Vacar said to the trustee that the father owned the flat, that was untrue and known to be untrue. In other words, Vacar was lying. He doesn't anywhere discuss the question of whether there was an agreement in Bilal's room in Cromwell Hospital in December 1991 to withdraw the existing proceedings, because he wasn't concerned with existing proceedings, he was concerned with new proceedings. Paragraph 88 is where he says in the last two sentences, the upshot was that both sons regarded themselves as released from whatever obligations they felt towards father and free to litigate and resume where they left off back in 1987-8. That wasn't an issue in the claim. He wasn't making any finding on it. The only thing he was making a finding on was that it was an abuse of the process of the court for Vacar to rely on adverse possession in the light of what he said to Mr. Jarvis. So, I mean, if Judge Gerald had been concerned with that issue, he would have had to address it. He would have had to address the fact that there had been evidence put before Mr. Jarvis, saying that there was an agreement, and that evidence was also before him, an agreement in December 1991 to discontinue the previous actions. And he doesn't address that evidence. And he would need to address what Mr. Jarvis had to say on that as well, which he doesn't. Mr. Jarvis said that it was more likely than not that there had been an agreement to discontinue, because it was very unlikely that the existing actions would be left hanging as a sword of Damocles. He didn't decide the point, but he inclined in that direction. So if Judge Gerald really had been concerned with that issue, one would expect him to have addressed Sarah's evidence, Ilias's evidence, and what Mr. Jarvis had to say about the inherent probabilities. And he doesn't do any of those things. So in our submission, Vacar was entitled to rely, and is entitled to rely, on the evidence in his 2011 witness statement about what was agreed in the Cromwell Hospital in December 1991. And as Mr. Jarvis said, if there was such an agreement, it would be wrong to lift for stay. As Mr. Jarvis said, you can't decide whether there was such an agreement unless you try it. And that would be a wrong thing to do. And Mr. Justice Bacon gave 4 reasons, in essence, for rejecting that argument. The first was that the witness statement was made a long time ago for a different application. The second was the situation had changed because his accounts as to the basis of his entitlement had been robustly rejected. And the third was he didn't rely on this contention in the 2017 proceedings. And the fourth was what Judge Gerald said in paragraph 88, which we've just looked at. So,
sorry, what's the fourth point?
the fourth point was that Judge Gerald made a finding in paragraph 88 that both sons regarded themselves as released from whatever obligations they felt towards father and free to litigate and resume where they left off back in 1987-88. That's what she said in paragraph 142 of her judgment. So the first point was that it was made for a different application. In my submission, that's no reason to refuse to consider it. The fact that a witness statement is made for an application doesn't affect the fact that it's evidence of what the witness remembers, and there's nothing to prevent it from being relied on a different application. As to the passage of time, one would expect a recollection in 2011 to be better than one in 2022. That's not a reason to refuse to have regard to evidence. As to Judge Gerald's negative assessment of Vacar's evidence, that was in a different action and therefore irrelevant. And in any event, it didn't apply to this, and it didn't apply to everything. If one looks in paragraphs 82 and 83 of Judge Gerald's judgment, he discusses there the question of whether Vacar is right in saying that the 1992 agreement related to the flat, or whether Iftikhar is right in saying that it didn't. And in paragraph 83, he says it's common ground that there was an agreement. It's not material whether it was encompassed within the 1992 agreement or a later oral one in 1992 or 1993, although it most probably was encompassed within that agreement. So he's saying that Vacar is more likely to be right than Iftikhar on that point. If one looks at page 228 in the core bundle, paragraph 26, paragraph 25 is where he makes his negative assessment of Vacar's evidence. But in the last sentence there, he says there were some aspects of his evidence which I found to be more credible than Iftikhar's and father's. So it's not as though Judge Gerald said that everything Vacar says is wrong. He says some things he says are wrong and some things are more reliable. He didn't make a finding either way on this evidence about what happened in Cromwell Hospital in December 1991. So in my submission, there would have been no justification for making Vakar make another witness statement, repeating what he'd already said. And it's difficult to see how a witness can be expected to revise their recollection of what happened, because the judge has said, I don't accept your evidence on some things. The witness's task is to give evidence about what they remember. A judge's task is to assess that evidence. Just because a judge has said, well, I reject Vakar's evidence on certain topics, therefore Vakar has to make a witness statement saying, well, the evidence that he didn't consider is still my evidence. I haven't changed my recollection of what happened in 1991. That can't be right in my submission, that he should have to do that before the court will consider what he has to say on the subject. So in my submission, there are 3 points about Judge Gerald's robust assessment of Vakar's evidence. First, it was irrelevant in the 1987 possession action, for reasons I've already explained. Second, he said in some instances Vakar's evidence was to be preferred. And third, if he was dealing with this issue, which he didn't, he would have to have taken into account factors that he didn't take into account, which just shows that he'd never considered it and wasn't required to consider it. The
paragraph 86,
Yeah.
is on Judge Gerald's judgment. Does he not reach a conclusion in the last 7 or 8 lines, 6 lines? Consistent with what I was told with Pakistani patriarchal culture and the way in which this family operated, this agreement was intended to enable peaceful resolution, but if for whatever reasons father did not preside, none would be prejudiced, i.e. they could go back to their pre-existing positions. That's inconsistent, isn't it, with Vakar's evidence? So it must have been an implicit rejection of it.
Well, Lord, I've really made my submission that it wasn't an issue whether an agreement had been made to stay the 1987 possession action, or whether an agreement had been made that it should be discontinued. That had no relevance to the issues that the judge had to decide. What Iftikhar had actually done was not try to resurrect the 1987 possession action. What he'd actually done is started a new possession action. So it wasn't necessary for the judge to consider that. And whatever he said on this subject wasn't addressed to that issue. The issue he was addressing was whether there was an agreement that father was the owner of the flat. But the fact that a judge uses particular language when considering one issue without directing their mind to a different issue shouldn't be taken as a finding on that different issue, which they never considered. Now, I see your lordship's point as to the way the language reads. I do see that, but
the question here, isn't it, is not whether he was entitled to make that finding, because on the basis it wasn't a matter in issue, but if he has made that finding, wasn't Mrs. Justice Bacon's point that the judge having made that finding on a witness statement prior to that judge making the finding, it was incumbent on Vakar to produce some further evidence to respond to that?
well, in my submission, if that was the point, then it's unsound, because it's taking something a judge said in a different action concerned with different issues and treating it as though it's applicable in this action. And the reason I took the court to Spencer Bauer is because to make it clear that that's not appropriate. In any event, what could Vakar say? Well, the judge said I wasn't right, but that's how I remember it. That's what I say happened. What's he supposed to do? What new statement is he supposed to say? I still say what I said happened, despite what Judge Gerald said. The next error we say that was made here was when Mrs. Justice Bacon took into account Vakar's failure to raise the 1991 agreement in his defence and counterclaim in the 2017 claim.
Sorry, she took into account.
In paragraph 142 of her judgment, she said it is notable that while Vakar said in 2011 that the 1992 agreement included an agreement to discontinue the English litigation, he did not apparently pursue that contention in his defence and counterclaim to the Part 20 claim in the 2017 proceedings, or in his application to strike out that claim, or in his submissions at the trial. So she took that into account, and that was an error in my submission because it was completely irrelevant to the 2017 claim. didn't make any difference whether there was an agreement of the kind he had said was made in the Cromwell Hospital or not. It couldn't be a defence. It couldn't be relevant to the 2017 claim, because the 2017 claim was a new claim, and the Cromwell Hospital agreement had nothing to say about that, subject to my Lord Justice Zacaroli's point, which I've addressed. So, my ladies, my lord, those are the submissions we have to make on the errors that we say were made by the learned judge in her assessment, which led her to decide to live for stay after 35 years, after the practice direction which provided for the stay had itself been removed because it was thought to be spent. And we respectfully invite the court to determine that there were errors that invalidated her determination, and to remake that determination and to determine that the stay should not be lifted. We also have an appeal on the question of costs, which I'll take briefly, because we've said what we want to say about that in our skeleton. I don't really have anything to add. The order is in the core bundle at tab 12. Which starts on page 166. The cost order we wish to challenge on page 169 at paragraph 6. The costs of the application are to be paid by Vacar to Iftikhar. The reasons that are given for that costs order are given on page 170 at paragraphs 1 and 2. And paragraph 1, she says, the application was one where Iftikhar was wholly successful, but it involved a request for relief from sanctions, in relation to which the general principle is that the party who applies for relief from sanctions should bear their own cost of the application, and in many cases may also be required to bear the cost of the party resisting the application. The incident of cost is, however, discretionary, and the court must take account of all relevant factors of the case before it. And I'm not saying that was a misdirection, but I'm saying that applying those principles, the only correct decision here would have been to at least say that Iftikhar should bear his own costs, and overall to say that he should also pay Vacar's costs, but certainly not that Vacar should pay his costs. And the factors she identified in paragraph 2 were the procedural history was highly unusual, in particular following the uncontested findings of H.H. Gerald in the 2018 claim as to the original ownership of the flat. The substance of the 1987 action was no longer contested by Vacar at the hearing. That's true. Iftikhar's success in the application therefore determined the 1987 action in its entirety. Well, it didn't. It only did that if the application to lift the stay succeeded. Then she says that in turn meant that Iftikhar was overall the successful party in the very long-running litigation, despite losing the appeal. Again, that only follows if the stay is lifted. So she is, in my respectful submission, taking into account matters that should not be taken into account. In addition, while Vacar relies on the long delay to contend that Iftikhar should bear the cost of the application, the position at the hearing was that Vacar had served no evidence, whereas Iftikhar had provided good reasons for the delay. I've already made my submissions about that. So even if my overall attack on the judgment doesn't succeed, I do invite the court to say that the learned judge was wrong to say there were good reasons for the delay. And then she says, and the other compelling reasons for lifting the stay given the circumstances of the case, including the fact that Vacar's possession of the flat was wrongful from the outset, depriving Iftikhar of a very valuable property of which he was the legal and beneficial owner. That is no more than saying that Iftikhar succeeded, which is not enough, can't be enough to take the case out of the general principle. General principles that are referred to, which she briefly summarised, are set out in the Swivel case. That is in the authorities bundle. I don't think it's necessary to take the court to it. So in our submission, applying those principles and stripping out the irrelevant factors, the right order is certainly that Iftikhar bears his own costs of the application. And in my submission, he should be ordered to pay Bakar's costs. Bakar's resistance to the application was considered and proportionate and not opportunistic. So reasonable. Bakar acted reasonably in contesting the application even though he was unsuccessful. Maybe those are my submissions.
Thank you. Any questions? No, thank you very much. Well, immaculate timing, if I may say so. Mr. Jordan. 2 o'clock, please.
Surprise.